The purpose of this short video is to teach some of the basics and customs of depositions, civil depositions in the state of Iowa. My name is Tom Hillers. I'm an attorney with Hupy and Abraham, and I'm also the president of the Young Lawyers Division. This is Susan Fry. I'll let her introduce herself.
Susan Fry. I'm a freelance court reporter here in Des Moines.
My name is Michael Keener. I'm in my 7th year of practice at Grief and Sydney here in Des Moines. I will be conducting the deposition.
Ben Erickson. I am in my 2nd year of practice at Grief and Sydney, and I will be defending the deposition.
So for the purpose of this deposition, we are setting out facts whereby Mrs. Smith, Ben Erickson's client, is suing her neighbor based upon a dispute over a strip of property between their two parcels. One of the first questions that we often get when it's someone's first deposition is simply, how is the seating set up? So typically in Iowa, if you are defending a deposition, meaning it's your client or a witness who is favorable to your side, you will sit next to the witness. The court reporter always sits at the end of the table next to the witness. So when your client or your witness comes in, they are going to sit just adjacent to the court reporter. And finally, the individual attorney who is going to be taking the deposition sits across the table from the witness. And the way that you could know if that's you is if you notice the deposition. So if you send out the notice for the deposition, you'll be the one asking the questions to start off with from the witness. The next thing that we typically get questions about are, how do I deal with exhibits, or how does the deposition start? So once everyone is seated, the court reporter may ask the attorney if they want to mark exhibits. You can either mark them before you start, or you can mark them as you go. Most attorneys have the exhibits marked as they go. Then the court reporter will ask everyone if they are ready, and the court reporter will swear the witness. So Susan, it's all yours.
Would you raise your right hand, please? Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth? I do. Thank you.
Now, frequently, the attorney taking the deposition will set out a few ground rules, and I'll let Mr. Keener take it from here.
Mrs. Smith, my name is Michael Keener. I represent the defendant in this action, the Johnson family. Mrs. Smith, have you ever had your deposition taken before?
No.
So as you see here today, we have a court reporter sitting between us. And over the course of the next couple hours, I'm going to be asking you a series of questions. Now, as you can see, there are 2 of us and only 1 of her. So it's important that when I'm asking a question and you're giving the answers, that we don't speak over each other. So I would ask that you would wait until I finish asking my question, and then in return, I will also wait until you finish your answer. That's not fair.
Yes.
Also, this is not an endurance test. If at any time you need to take a break to go to the bathroom or get a glass of water, please just let me know. We can take a break. I would only ask that if there is a question pending, that you answer that question before we take the break. You understand that?
Yes.
Also, and you're doing a good job of this already, it's important that you give audible answers. So, as I said, Susan here is taking down everything we say on paper. So if I ask a question that's yes or no and all you do is shake your head, that doesn't show up well on paper. Or if you give an or an that can be unclear. So it's important that if it's a yes or no question, you answer yes or no. Is that fair?
Yes.
And if I do come back and say, is that a yes or is that a no, it's not trying to pick on you. Just making sure that your answer is fairly exemplified on the record. Is that fair?
Yes.
And finally, if at any point I ask a question that you don't understand, please let me know, and I will rephrase it to make sure that you understand what I'm asking. The reason this is important is, for purposes of the record, if you answer my question, we're going to assume that you understood what I was asking. You understand that as well?
Yes.
All right.
So one additional point here, that sometimes attorneys start the deposition with a stipulation. Typically in Iowa, the custom is that the attorneys do not start out with a stipulation. However, we want to show you one of the tricks involved that some attorneys from time to time try to play in depositions. So I'll let Mr. Keener start with the standard Iowa Civil Procedure Discovery Stipulation.
This deposition is being taken pursuant to the Iowa Rules of Civil Procedure. Any objections other than the form of the question or privilege are preserved to be raised at the time of trial. So stipulated, counsel?
Yes.
Okay, now let's hear the trap.
This deposition is being taken pursuant to the Iowa Rules of Civil Procedure, and any objections must be made herein or they are deemed to be waived. So stipulated?
Did you hear that? Any objections must be made or it is deemed waived. That stipulation is only proper if you have agreed that the deposition is going to be played or read for the jury in lieu of testimony at trial. That is commonly known as an evidentiary deposition. While we're on the topic of evidentiary depositions, don't go looking through the procedures for an evidentiary deposition in your rules book. Evidentiary depositions are taken when certain witnesses cannot be present for trial, and they exist in Iowa somewhat as a professional courtesy among practicing attorneys. They are taken as though the witness is sitting on the stand at trial. The typical deposition in Iowa is called a discovery deposition, which allows the questioner to inquire about any matter that could lead to the discovery of relevant evidence, meaning that in an evidentiary deposition, you must make relevance objections. However, with a discovery deposition, you only object to relevance if the question could not in any way lead to evidence that makes a material fact more or less likely. And that's just one example of the distinction between evidentiary and discovery depositions. If an attorney tries to make an evidentiary stipulation in a discovery deposition, simply state, "We stipulate that this deposition is being taken pursuant to the Iowa Rules of Civil Procedure, and any matters related to the deposition will be governed by those rules."
Mrs. Smith, isn't it true that for 15 years, my client mowed this strip of land, and not one single time did you go out and mention that it in fact was your land?
I'm going to object to the form of the question as it's a mischaracterization of the evidence. You can go ahead and answer.
What was the question again?
I'd ask the reporter to please repeat the question to the witness.
Mrs. Smith, isn't it true that for 15 years my client mowed this strip of land and not one single time did you go out and mention that it in fact was your land?
I would say that the custom in Iowa is to not make objections during discovery depositions. And most attorneys start out by asking a lot of background questions of the witness. For the purpose of this deposition, though, we'll move straight to the objections that you need to know for a discovery deposition. Objections in discovery depositions are governed by Iowa Rule of Civil Procedure 1.7175. It reads as follows. Testimony taken by deposition may be objected to at trial on any ground which would require its exclusion if given by a witness in open court, and objections to the testimony or competency of a witness need not be made prior to or during the deposition, unless the grounds thereof could then have been obviated or removed. So essentially, all objections are preserved for trial unless the reason for the objection could have been fixed if a timely objection had been made. The most frequent example of the grounds that could be cured are found in the form of the question objections. I'll give you a list here of the most common form of the question objections, and then Mr. Keener and Mr. Erickson can provide some examples for you as well. The typical form of the question examples are leading, assumes facts not in evidence, mischaracterizes the evidence, compound, and asked and answered.
Mrs. Smith, you would agree that the survey shows that the strip of land is on my client's property, and that has always been the agreement between you two.
I'm going to object to the form of the question as it's a compound. You can go ahead and answer.
That's correct.
The witness has just answered 2 questions. Many witnesses will only hear the first part of the question, and then they will blurt out the answer without listening to the rest of the question.
The county engineer believes that the strip of land is on my client's property. So why are you suing my client?
Objection, assumes facts not in evidence.
There has not been any evidence about what the county engineer's position is on the issue. This is a good example of a question where the trial objection would be hearsay as to what the county engineer said, but in the deposition, the objection is to the form of the question, as it assumes facts that are not in evidence.
Mrs. Smith, you testified earlier that there was an agreement that the land was on my client's property.
I'm going to object to the form of the question as it mischaracterizes the evidence. She answered an objectionable compound question.
In the heat of a deposition, attorneys often fail to remember the exact nature of the prior testimony as the hours drag on. Mr. Erickson's deposition is, to some extent, a speaking objection in that he describes the nature of the mischaracterization. However, it is often better to be more specific to alert the other attorney as to the exact mischaracterization so that it can be fixed during the deposition. Let's talk briefly about foundation objections. Foundation, within the context of a discovery deposition, can mean a couple of different things. It can mean the witness has no personal knowledge of the issue. It can mean that a document has not been properly identified or authenticated. And it can mean that the witness lacks the qualifications to testify as an expert. The most common example is lack of personal knowledge, and an objection to that foundation must be made during the deposition. Go ahead, Mr. Keener.
I'd like to ask the reporter if we could please go off the record. Can we mark this, please? Okay, we're good to go back on the record. Mrs. Smith, I'm going to hand you what the reporter has marked as Deposition Exhibit 1. Ask you to take a look at that. Mrs. Smith, have you seen this document before?
No,
What is it?
I have no idea.
I will represent to you that it's the county engineer's letter to me stating that the land is owned by my client. Isn't that true?
Objection, foundation, the witness lacks personal knowledge.
Once the witness has testified that she's never seen the document before and she doesn't know what it is, at that point she lacks personal knowledge to testify as to what is stated within the document or even to identify the document. So the proper objection is foundation, lack of personal knowledge. Finally, let's talk about directing a client not to answer a question and what to do after you've directed a client not to answer a question. Go ahead, Mr. Keener.
Isn't it true that you manufacture and sell methamphetamine out of your basement?
Objection, privilege against self-incrimination. I'm going to ask you not to answer the question.
Counsel, are you instructing your witness not to answer the question?
I am.
And I would represent that this question does not present her with criminal liability. Are you still asking your witness not to answer the question?
I am. I'm just going to disagree with your assessment of it.
Well, I guess we're going to have to call the judge.
So typically in Iowa, most attorneys will call the judge if there's a specially assigned judge on the case. If you're in a district where there's not a specially assigned judge on the case, then you will call down to the local courthouse where your action is venued at and see if there's a judge in the courthouse who can answer the question. If not, then you call any judge within the district and Typically, the judge is more than willing to help you resolve your discovery dispute over the phone so that you can move forward with your deposition. If not, you can simply proceed forward with the deposition, and then after the deposition is concluded, you can file an appropriate motion under the civil rules to have it set for hearing, and there are provisions for sanctions under those rules if the direction not to answer the question was improper.